Well, hello and welcome to PM Express. And let me apologize because I know many of my viewers were tuning in to the program, which are team number 12 versus Who Watches the Watchman, and it generated a lot of interest. But who knows, the Flagstaff House has just launched an even bigger bombshell. And so we decided that, you know, in your own interest, it was best that we discuss this. EC3 dismissed. EC3 dismissed. And I'm sure you all know that right after the 2016 election, there was a lot of brouhaha at the EC where the top hierarchy were simply not getting on. And there was rumors and allegations and rumors and allegations. And so the Chief Justice had to set up a panel and look into what was happening there. This afternoon, a statement has been released that the three have been relieved of their duty, and that's Mr. Amadou Sule, Mrs. Georgina Abankwa, and Madame Charlotte to say have been asked to leave. Once we want to find out what are the legal implications, what are the constitutional implications, but it's major news. So that's what we are going to discuss today, and at a fine time we'll come back and look at number 12 versus Who Watches the Watchman. So we've just sheltered. But today, the EC3 have been asked to go home, leave off their post. Big news. My name is Nana Ansakwa IV, Chief of the Little Republic of Akufo-Addo. And when I come back, I have two fine editors in studio to analyze, give us a chronology of how things began and why it is we got here. Don't go. Well, I have my two brothers with me in studio, so I am absolutely safe. With me in studio is the analytical Malik Dabo. Hello, Malik.
Good to be here, Nana.
And the legendary Evans Mensah. If you're ever running for presidential, presidential hopeful, and they are voting, you hope that he has a headache that day, because if you're out, he will come and announce it before. Evans, you're welcome.
Nana, thank you.
And tell you how statistically impossible it is.
that you would win. Samson Laddie will join us on the phone later and give us the legal angle. But I just want us to start a chronology and the history of this whole EC saga. So, Malik, since you're so analytical, let me hand you that.
Okay, so now let's start with the processes that lead to what has brought us where we are now. That the three most important people at the top of the Electoral Commission, the elections governing body of Ghana, have been asked to go home. We have to start from Article 43 of the Constitution. Article 43 says that there shall be an Electoral Commission who shall comprise of, this is 43(1), who shall comprise of A, a chairman, B, 2 deputies, and then C, 4 other members. Now 44 is instructive. 44(2) says that the chairman of the Electoral Commission shall have the terms and conditions which are applicable to those of a Court of Appeal judge. And it is important for us to note these nuances, because the processes that were adopted in removing them would all hinge on these constitutional provisions. So 44(2) says the chairman of the Electoral Commission shall enjoy the terms and conditions of the Court of Appeal judge. And of course 44(3) says that of the other 2 deputies, they shall enjoy the terms and conditions of the High Court judge. Now if you go and look at Article 146, Article 146 states what will happen if you want to remove a Court of Appeal judge or the Superior Court judges. The Superior Court judges, the Superior Courts are the High Court, the Court of Appeal, and the Supreme Court. Now, if you have Article 44(2) telling you that the chairman of the Electoral Commission enjoys the terms and conditions of a Court of Appeal judge, if you want to remove that chairman of the Electoral Commission, the processes to adopt are the same processes which are applicable when you are going to remove a Court of Appeal judge or a Supreme Court judge or a High Court judge. And those processes have been laid out in Article 146 of the Constitution. Now, if you go look at Article 146(1) of the Constitution, it says that a superior court judge can only be removed from office on grounds of stated misbehavior or incompetence, or proof that the person is incapable of performing their functions. So these are the processes as laid out. If you look at 146(3), it says that if the president receives a petition, which means that the only conditions under which the president can remove a superior court judge or the electoral commission chairperson or the deputies or Chiraj commissioner or NCC commissioner, is to send a petition to the president. 146(3) says that if the president receives a petition in respect of removing any of these persons, that petition shall be referred to the Chief Justice. Now, 146(4) says that if the Chief Justice receives the petition as referred to him or her by the president, the CJ must establish prima facie case that there is a matter to answer. And prima facie simply means that on the face of the evidence presented, or on the face of the petition, the CJ believes that there are questions to answer. That's what they mean by prima facie evidence. So the president receives a petition, that petition must be referred to the Chief Justice. The Chief Justice must establish prima facie case to answer. If the Chief Justice establishes a prima facie, the Constitution in 146 says that the Chief Justice must set up a committee. This committee must be comprised of 5 people. 3 of the 5 people must be members of the Superior Court, i.e. High Court, Court of Appeal, or Supreme Court. And then 2 other members who are neither lawyers, they are neither members of Parliament, they are neither members of the Council of State. That makes 5. These 5 people will investigate the complaints contained in the petition. When they have finished their investigations, they shall make recommendations to the Chief Justice. The Chief Justice, upon receipt of those recommendations, shall forward same to the President. And Article 146(9) says that the President shall act in accordance with the recommendations of the committee that have been forwarded to him by the Chief Justice. That the President does not have an option whether or not to accept the recommendations. Article 146(9) says that when the recommendations have been made by the committee set up by the Chief Justice, which recommendations would have been sent to the CJ because it's the CJ who set up the committee. When the CJ forwards these recommendations to the President must act in accordance with the recommendations of the committee.
Which is what the President had done tonight.
Which is what the President has done tonight.
And we'll come to the reaction shortly. But so he's laid out the legal processes. And so somebody needed to trigger this. And so in July last year, a group calling themselves Concerned Staff of the Electoral Commission put together a petition. And they were led by renowned lawyer Max Akufo-Addo. And then they sent this petition to the President, triggering the clause in the Constitution which Malik had just spoken about. In that particular petition, they made a 27-point, they laid out 27 allegations against Madam Charlotte Osei. And it ranges from things like that Charlotte Osei had acted in a way that was politically compromising. In fact, they have stated that he acted in a way that compromised her independence and neutrality as a commission chair, because she arranged, according to them in an allegation, for a 2015 V8 from the then government with registration number WR229115 from John Dramani Mahama, which she got. Now, they also went ahead to state that she also had a political posture, which she shouldn't have had because she's a chairperson of the Electoral Commission.
She's required to be independent.
And that without recourse to the Commission, also engage the services of lawyers. That's law. Yes, without going through the procurement process, contrary to the Public Procurement Act. And that further indicated that the Commission signed a contract with Super Tech Limited on the premise that the voters' registration exercise was going to be electoral area based, But upon assumption of office, they claim that the chairperson of the commission, Mrs. Charlotte Osei, unilaterally abrogated the said contract without recourse to the same commission that had approved the earlier version. These are just 3 of the 27 grounds that inspired their petition to the president. The president, having received this, as Malik had indicated, had no choice than to hand that over to the Electoral Commission, to the Chief Justice, for her to commence a process that will establish whether there's a tiny basis, I guess, what he calls the prima facie, for there to be a full-blown investigations, which he did. And remember that the Chief Justice, after a while, after the committee, even before the committee, came back and said they found that and so Madam Charlotte said should respond. But something curious happened. 6 months or so after that petition had gone in and had gone to the Chief Justice and the prima facie had been made, then Charlotte comes and documents are leaked to us in which she's now asking the presidency to furnish her with an official copy of the petition that had been sent in July. And this was, I think, in December last year, which was a very curious thing to happen. That there's a petition against her. She's possibly going to lose her job for it. And she said, I haven't seen a formal copy of this. I haven't been given one. And so she was asking the presidency to give her a copy. I remember speaking to the Director of Communications then. And his position was, listen, this is out of our hands. We've given that petition to the Chief Justice. And so if you want a copy, you should go to the Chief Justice for a copy. Now,
there was a lot of brouhaha
back and forth
on this issue.
Something Ladaini had indicated when that documents became public knowledge, that she was asking for the official document, that it was pretty strange that 6 months on she's not had a copy, because he had gone to the process, the same process before when he was representing a client against the former chair of the Commission on Rights and Justice, and that they were given a copy, and so they had it. Having said that, that was the last we heard of Charlotte Osei. And then subsequent to that, she got a copy and she responds. She responds to every single one of the 27 allegations against her. It's interesting what she put in their response. That is when we started seeing, I guess, the rift not only between herself and the so-called staff. And a huge deal was made of the fact that the identities of the
faceless,
exactly, of these individuals were not known. And the NDC made a meal of it, but also others, lawyers and private legal practitioners made a meal of it as well. I mean, raising questions about if Charlotte Osei actually asked for the identities of these individuals to be made known to her, so she knows who her accusers are. But the counter-argument then was, when you go before the CJ's committee, you definitely know these individuals. Absolutely. So Charlotte responds to the 27, and in her response, she then levels her own accusations against the 2 other deputies,
Amadou Sule
and Georgina Opoku-Amankwa. Yeah. One of the allegations she leveled, for example, is that in one of the accusations was that she had contracted lawyer Tyler Sorry and his chambers without due process. In fact, she alleges in her response that this is a process that the entire commission agreed to embark on. And in one occasion, when monies became an issue, how to pay Thaddeus and his firm. And it was agreed that you cannot predetermine how much. You should only do so on a case-by-case basis, because cases go to the Supreme Court and High Court, and that determines how much. And she alleges that apparently the deputy chair, and in this case, Georgina Opoku-Amankwa, had a previous dealing already on this matter with other law firms under similar circumstances.
That's retainership.
Retainership. And that she has even found that in some cases, some of these law firms that she had engaged in the past had not been paid 4 years after they had rendered the service. And so she was curious that a big deal was being made of this when Madam Georgina Opoku-Amankwa had already, this is the established protocol, this is how this commission had acted all the while. And I remember that this part of this case had gone to Iyoko,
which was also Madam Charlotte Osei's own complaints to Iyoko to investigate the Deputy Commissioner Georgina Opoku-Amankwa And there were a raft of allegations contained in that petition or in that complaint that the EC chair was reported to have sent to Yoko. In fact, on the basis of those complaints, Yoko then wrote to Georgina Opoku-Amankwah asking her to step aside.
Yeah.
And remember that itself became a subject of constitutional argument.
And in fact, if you're watching the television, you would have seen a bit of Georgina Opoku-Amankwah in her office that day. In fact, she made a media spectacle of the fact that
there were armed police and everything.
There was no way she was going to leave her office, and invited us into her office. We sat there with her for hours. Policemen had come wanting to physically remove her from her office, and she said, I want to go. In fact, it took the boss of Iyoko to go there and negotiate with her to sort of back off. And then her lawyers...
I think what you're describing is on the...
Which is what we're now watching. Her lawyers that evening told us that, well, the only concession they'll make is, we will give you 2 weeks to sort this thing out, because after 2 weeks, we are coming back to take our office. And from what we hear, apparently she's been...
But Evans, remember that even the Yoko letter itself, when the Yoko letter came, I argued forcefully on radio that I did not think that there was a constitutional basis for Yoko's letter, because as I laid out in Article 146, there was no room for Yoko to write to the Deputy Commissioner of the Electoral Commission asking her to proceed on leave because some investigations were being conducted.
The interesting point, though, that she and a lawyer somehow agreed to sort of comply with that directive. Exactly. The lawyer admits that there was no legal basis, but they felt they had to do it, and now they felt this was dragging, and so let's exercise our right and do what we should have done in the first place.
But I mean, this is big news. It's just happened, and I can imagine by tomorrow the usual political angle will come in. I mean, we politicize.
It has actually already started.
Now, this is one thing. Now, you see, this ID card issues, Ghana card business, and it's been, seriously linked to voting.
Yeah.
Let ID cards come in. We said no. So there's been back and forth where the NDC are not happy that you can't, get a Ghana card with a voter's ID. Whether we like it or not, we had Kennedy Japon, who was, was furious saying, look, we don't like this lady because she's a bit tied, too close to Kennedy Japon.
The NDC has cited that tonight already.
Okay, so it's like, this is our girl, whether we like it or not. Not said, but...
implied.
Yeah, implied. So I can imagine that, well, it's a ploy. They don't want us to use ID cards. Now they're kicking this lady out, which means it's a big, grand plan for...
Those are the exact words of the national organizer of the NDC, Akufo-Addo, tonight. In fact, he says categorically that what has happened tonight is a political decision that has been taken, regardless of the fact that the Constitution backs it, and it's a constitutional process, as Malik had laid out. It is a political decision, and that the NPP has been determined from day one to remove Madame Charlotte Osei, and they had to find the legal processes that will back that agenda and get her out. And so these faceless individuals who we never knew, at least publicly we didn't know, Charlotte Osei would have met them at the committee because they will have the opportunity to cross-examine them.
Absolutely.
That is how these faceless individuals were sort of hired to put in this petition to the president, and the president swiftly acts. And so that is the NDC's position. And they have served notice tonight that they are going to fight this decision. How they do that, I don't know. Because I have been speaking to the lawyers for Charlotte Osei, who tell us that they will think through their options. And one of their options is to fight this at the Supreme Court. I wonder how the NDC can fight this, other than to anticipate. They will also adopt a political approach to fighting this. You probably will see press conferences, we'll see protests, etc., etc. But something significant, Malik, and we need to analyze it quite closely. There is this political attachment to Electoral Commission chairpersons in the past. There's always this perception by the party in opposition that the guy who is at the helm of the EC, if we did not appoint the person, then maybe that person will act against our interest. And the party in power if they get to a point, then there's a certain belief that that person, female or male, may act in our favor. It beats my imagination because and that is why you made the point that it has been implied that Charlotte say because John Mahama appointed her, she will act in favor of the NDC somehow, and so the NDC guys protect and defend her actions.
Literally spokespersons for her.
For her. And they will defend. In fact, that's why the NDC is taking this position today, that what the president has done is simply find a way to remove her and sort of leave the commission without somebody there, impliedly, who is sort of sympathetic to the NDC's cause. The NPP people probably also impliedly have also thought and acted, and you mentioned the likes of Kennedy Pond, when they were in opposition, fought Charlotte say quite vehemently on every single decision that she took. They fought. However, if you look at the facts, it shows that whoever is at the helm or at the EC doesn't have any influence whatsoever on the outcome of our elections. Since 1992, since Afarijan was appointed by the Rawlings regime, right? Stayed there. Rawlings won under his watch, Afarijan. Rawlings NDC lost under his watch. Kufuor came to meet him. They fought him on many issues. Kufuor lost the elections under Afarijan's watch. You remember?
Won twice.
In 2000, won twice. That's the point I'm making. So it doesn't really matter. In 2008, they fought Afarijan on a lot of the NDC. Raised a lot of issues. In 2012, the NPP in opposition, remember, fought Afarijan consistently on a lot of issues and eventually went to court. They lost. The biggest case for me is 2016. John Dramani Mahama appointed Charlotte to say, and yet received the NDC's heaviest defeat yet. The woman who people thought that John Mahama appointed has been accused of, you don't even want to repeat the allegation, that Charlotte say has something, an affair or whatever it is, with John Mahama, and so got the appointment. Yes. An allegation made by Kennedy Pond. That woman, the concerned staff of the EC, faceless individuals, we don't know them, alleged that got a vehicle, a V8 from John Mahama, and that she had acted and her posturing was not neutral. That same woman presided over an election which delivered the biggest defeat for the NDC. I mean, and switch it, also delivered the biggest victory for the NPP. The same party that was fighting Charlotte say every turn, every step of the way.
You have the opinion that it doesn't matter who's there.
Absolutely. Well, our history since 1992 has shown, 2016, my biggest evidence yet, it does not matter who is there. Nanado will get to a point, if indeed Charlotte decides not to fight this, or even if they decides to fight and loses, we'll get to appoint somebody. My point is, whoever Nanado appoints, our history has shown, more than 2 decades of democracy and the 1992 Constitution has shown that it does not matter. And yet tomorrow we are going to see political camps pitched, one on the side of EC and the two deputies that are being fired tonight, us in the NDC, protesting. We'll find the MPP guys defending and saying it's good for them to go.
On that note, let me go on the phone. We have Samson Ladi Ayenini, who's a private legal practitioner and a family member of this very media house. Samson, you're welcome.
Hello, Nana.
Hi, Samson. Thank you very much for... Samson, now let me take you up on this thing. Now, in the Constitution, in order to remove such high officials, they must be shown to be incompetent and not being able to do the work. Could that be the reason why the statement released from Flagstaff House is saying that they have been relieved of the position for being incompetent? Because I was wondering why you would put such strong words in that letter.
The descriptions are simply quotations or repetitions of what you find in the Constitution. So, in fact, this letter communicating the recommendations of the committee that was set up to probe the matter simply has avoided giving you any details and may not want to get into trouble, and so simply repeat the constitutional language. The grounds are stated misbehavior, incompetence, or ill health. There are 3 grounds. So they've simply repeated what you find in the Constitution. They've not said anything. They've said practically nothing.
Samson, it's come as a surprise. I don't know how much secretive they can do it, but we never heard of the committee sitting. We never heard any news. It just boom, this letter comes out. I mean, legally, is that what is done, or should they have been keeping us updated? Because we had Roxanne Dafiamako in Parliament who was saying, look, we never heard anything apart from this letter.
Well, it's unfortunate, and Roxanne is a good friend of mine. In fact, there is a group of lawyers that he's president of, and I'm vice president, an interim body that was set up. That doesn't mean that, it takes away my ability to criticize him when he's refusing to read the law or has read the law but is simply doing his politics. Because the Constitution is very clear in the terms of how the process ought to be conducted. And it says that this process should be conducted in camera, meaning it is done without the public knowing what is going on in there. It is done in secret. It is done in confidence. It is only the people who have been accused or those who are accusing whoever it is and their lawyers and the committee members who get to know what is going on from each day. So when, for example, the House prosecuting the Lawrence Alamte removal from SHRAG had media, including from our own, network, come to the Supreme Court premises and accost you after the process and ask questions, I would simply decline to say anything because I had been injuncted by law, by the Constitution, to keep the confidentiality of the process.
I see. So that's
in fact,
law.
The Supreme Court has said that there are a number of punishments, about 4 punishments, if you disclose the confidence, if you break the confidence that ought to happen in this process.
Wow.
We ought to know clearly one issue that is already coming up and that we need to clearly identify is that when you take the politics away and you stick to the law, number 1, the process ought to be done in camera. Number 2, the language that is used in the letter is a repetition of the Constitution's own choice of words. Number 3, the President has simply done a communication of the recommendations of the committee because Article 146, Clause 9 is emphatic. Says that the President shall act in accordance with the recommendations of the committee. What that means is that he has absolutely no say. He cannot alter anything that has been done or recommended by the committee. It doesn't matter how unhappy or violently he disagrees with it. So, as I have already described the President in the Article 146 process, from the commencement he is a mere conveyor belt. Convey the petition to the Chief Justice. Then when the process is over, he becomes a mere announcer of the outcome. And there's wisdom for that kind of process. The framers of the Constitution thought it was that he being the one who will appoint these people who will be subjected through such an impeachment process, he ought to be aware of the process from beginning, and then he ought to be the one to sign off on the letter that says go home. It's as simple as that. Because he was his appointing authority, he should be given the opportunity to do the final, ceremony.
Samson, can these three officers say, look, I'm going to court, I'm getting my lawyers, I think I've been dismissed unfairly, and therefore I'm going to court, and, where can they take their case, if any?
And it will not be new. When the first time the process was invoked against officers of independent constitutional bodies, it was invoked against a deputy commissioner of the NCC. When it was finished, and Emmanuel Opong felt that he had not been fairly treated, he went to the Supreme Court. Except that he didn't get what he wanted. They have a right. If they feel that some part of the process or the process in its entirety is fraught with illegality, or that the basis of the conclusion do not accord with the evidence that was proffered by those who made the accusation, they have every right to impugn the process through the court. In fact, judges who have also, this process has been used to remove, have also gone to the Supreme Court and, sought to challenge the process. So there is opportunity for them to, challenge, but it obviously ought to be on very fair grounds.
Something, probably this is the first time, three people of the EC just, dismissed like that. Are there any legal implications? What then happens to the EC structure?
Well, this certainly is unprecedented, but there ought to be a first time for everything. So there could be the next time when all the 7 members of the commission are up, to be dismissed. It is possible. If a situation happens where all of them are found complicit, those who ought to go through the Article 146 process will go through that. Those who can simply be dismissed without going through that process, or who ought to be subjected to a different judicial process, will also go through it. So this is unprecedented. Yeah.
Let me come here. First, Charlotte Osei was, petitioned. She then goes in and says, well, Chairman Suwahabi, he also did this, she also did that. And then that was it. Everything is held in camera, and then they come and then all 3 go. Is it a case of, well, if you can't get on to, if you are not going to get along to work, then, all of you go home? Because, Charlotte was one that was, had 27 charges. She goes in and then also filed charges. Well, I wasn't the only one. He also did this. She also did that. And then that's it. And then we come back and all 3. So, is it safe to conclude that, well, if you can't work together, go home?
No. You see, as you have just identified, there was a petition first by what became known as a named person. Of course, that process, that fatality was cured because subsequently the lawyers involved, Marcelo Pokwajman to be specific, took the name of the persons involved to the presidency. Correct that defect. That defect, initially, some of us had argued was irredeemable, but he was able to cure it. And then there was another petition that came in against the two deputies. So it is two different petitions, one against Salvatore and another against her two deputies that went before the president and forwarded to the CJ. And we ought also to pay attention to something. It would be the case that the two were consolidated, and that is what was done. The two petitions were consolidated and determined as in one trial, so to speak. And then the issues that the committee had to determine were narrowed down. So at a certain point, it became public, even though it was supposed to be in secret. We got to know that the issues were narrowed down to about 7 or so, not the 27 and so on and so forth. They were narrowed down to just a few of them. And those were the matters that engaged both parties, giving their testimonies and getting cross-examined. And then when they finished their case, definitely writing arguments from both lawyers, and then the committee doing its recommendations and submitting the recommendations to the Chief Justice, who doesn't have any power to do anything to the recommendations. He can't tweak it, only has to now forward it to the president, and the president issues the letter on top of it.
Samson, let me give you one unfair question. One unfair question before I let you go. Now, when the whole thing started, a few months down the line, we had Charlotte say writing to the presidency to say, hey, I haven't gotten my charges or summons yet. And then after she got it, say, look, I don't even know who's charging me. So could you say she didn't get a good head start to make a good preparation? I don't know.
Well, I suppose that eventually she would have been furnished with all that she needed to get. And that is why we knew that it was got to a point. Both parties were asked to file what is known in law as their witness statement. So those who were making the accusations were asked to file the first, and then those who were coming to defend the accusations were asked to file the after. Now, the witness statement constituted their statement, so to speak. It constituted their evidence. And when you are doing the witness statement, that is where you attach your evidence. If you have video evidence, if you have documentary evidence to back the mere allegations, the bare allegations, not mere, bare allegations that spiraled into the public, then you attach them to your witness statement. And then when all these things were filed, then both parties had the opportunity to now cross-examine each person on the basis of what they had put forward as their witness statement, which contains their testimony and their evidence. What I am saying at this point now is that it may be the case that there's no precedent that when the process is over, you don't get to communicate what exactly transpired and then bring the public and citizens into the knowledge of the recommendations. There may not be a precedent, because as I speak to you, and I told Evans and Malik, when they were breaking the story, that as I speak to you now, in 2018, our case of the charge boss, we never got, not my client or myself, got a copy of the final report of the committee, except that because we had done the case, we went to the committee every day. We were cross-examining, taking evidence and cross-examining every party involved. We knew what had transpired. And because we also wrote the legal argument, finally, to convince the committee that the person we had cited for impeachment was in fact and in law was guilty. So we knew what to expect, and we knew the body of the evidence. But the general public was unaware. All they had was a letter from President Mahama in November of 2015 communicating that the committee had recommended her removal, and so she's removed. I am saying that may not be good enough, particularly when we are dealing with, officers or heads of independent constitutional bodies who are removed through this way. SHRAG bosses, EC bosses, NCCE bosses. These are independent constitutional bodies. And the public has a certain, affinity, has a certain, connection with them. So it may be important that we do not keep the outcome secret as the process itself, so that we can communicate at least a good portion of the outcome, so people will know exactly what went on and what evidence was proffered and how that evidence was evaluated and how the conclusions were made, so they can get closure to what is happening. It is for some of that reason that, for example, in the historic election petition, the courts were opened up so that the entire public will be taken through the whole thing, so that their emotions and everything, they will go through, and then when the outcome is reached, they can come to terms with the outcome. Otherwise, we may be setting ourselves up for some trouble.
Samson, thank you.
People don't know what happened.
Thank you so much for your input there. I'm going to take a quick break, and then I'll come back into studio and find out from where Samson was ending up. If the details are made open, will the minority side of the house be happy to say, well, if they found A, B, C, and D, then it couldn't have been a political decision? I'm coming straight back. Well, EC3 dismissed, asked to go home, sacked, however way you want to put it, but unprecedented, as Samson said. And Samson was just ending that maybe if we get the details of what it is that was based on their decision, everybody would have closure. Just looked at Franklin Kujo's Facebook, and he says, can we see the real reasons for the removal of the Electoral Commission? How different is this from a military tribunal? Just asking. Malik, let me start with you. You think if it came out, we can look at it and say, well, if these things were found, then look, we can't say anything about it.
It may be the case that if these things were out there for independent-minded people, they would look at the evidence and say, well... I
like independent. You say there are some people who...
Evans laid the background to the politicization of everything in this country, sometimes including things which are plainly absurd. And he gave you the historical antecedents when it comes to the opposition to the position of Electoral Commission chairpersons by parties when they are in opposition, and when they are in government, the fact that their position becomes different. And he just cited Afarijan. And I remember very, very well, prior to the 2000 elections, all the relentless allegations that the MPP leveled against Afarijan. In fact, in the sight of the MPP, he was the devil himself. When they won the 2000 elections, everything went quiet. 2004, it was the turn of the NDC to now start leveling allegations against the Electoral Commission and Afarijan. And I remember Asedin Ketia's relentless campaign and accusations against the EC, and the complaints about the EC having a bloated register, supported by Bernard Mona and the PNC. The electoral register was bloated, the elections were not credible, and there were threats of violence all over the place. When the NDC won the elections, and at that time when they were leveling all of these allegations, the General Secretary of the MPP had all of a sudden become spokesperson for the Electoral Commission. Suddenly, he had become spokesperson, and I'm talking about Nano Hininto, he had become spokesperson for the Electoral Commission. 2008, MPP loses the election, NDC wins, then the MPP starts accusing the Electoral Commission. Fast forward to 2012, and we know what the issues were. When the electoral petition went before the Supreme Court, you remember how the petitioner's lawyers labored to put Afarijan down and reduce him to nothing. All of that was geared towards discrediting the elections. And Evans, the reason why they do all of this is because the politicians recognize that once they create sufficient doubts in the minds of the average Ghanaian and pitch the Electoral Commission as working in favor of the incumbent, then they become underdogs. And because they are underdogs, the Ghanaian people will tend to vote for them because the Electoral Commission, which is supposed to be an independent umpire, which is supposed to be an independent referee, is branded as being in bed with the government.
Let me bring Evans in here. Evans,
therefore, vote for the opposition.
If reasons are given that, look, we found A on, Commissioner A, we found B on Commissioner B, would it bring that closure?
It will bring closure, and I agree with something. I found it scandalous that he says that they still doesn't know the real reasons that led to the decision that was taken. Something that told us that right now, and for me that is very strange. This is, and for him, he was a lawyer in the case, and he still doesn't know the real reason. So if something hasn't got it, there's no way we as members of the public can expect to get something on the EC chair.
It's not too sensitive.
And for me, that's the key thing. That for me, that is wrong. And really, there's no part of the process. This is a part of the process that says that it has we cannot be, the reasons cannot be published.
The Article 1468 says that all proceedings shall be held in camera.
Proceedings have ended.
True.
You know, and something was clear when he cited cases. Remember, in the case of Anas's investigation into the judicial bribery scandal, Justice Paul Utaderi, Justice Mustafa Habib Logo, and others went to court. The gravamen of their argument before the court was that Anas had screened the content of the video, which formed the basis of his petition to the president for their removal. And to the extent that the Constitution in 1468 says that all proceedings shall be held in camera, going to screen that was in clear violation of the Constitution. And there were decided cases like Ajechum and the Attorney General, in which Bright Akwete was the lawyer. There was a similar petition for the removal of the Chief Justice at the time. And there were cases that petition was leaked. And to the extent that that petition was leaked, the petition ought to be dismissed in accordance with the Constitution, and that was done. So there are decided cases, even in the Justice Derrick case.
I get the point
the
about
court held that the petition
what
cannot
the
be
law
made
says,
public.
but it doesn't make common. It doesn't make sense.
No, but
I understand
proceedings are
why.
over now.
Good. I understand why you want to keep the proceedings secret and private, but once it's over,
you make a decision,
and you are communicating to the public that a decision, such a sensitive matter, that a decision has been taken to remove the EC chairperson and her 2 deputies. All you tell us is incompetence and stated grounds of misbehavior. It is simply not enough. Why? Because it creates room for doubt. It creates room for speculation. It creates room for propaganda. All these are ingredients for some form of disaster.
And we have trust issues already.
We already have trust issues. And so there is a public interest argument there that we need to satisfy in communicating a decision, because there are political elements involved in this. And already we've seen what the NDC's point
except that's
has
what
been.
time
would allow
usually
us.
The Constitution does not concern itself with the kinds of constitutional concerns that you are raising. The Constitution grants the persons involved their right to be heard. They have access to a lawyer, and the Constitution said they can represent themselves or be represented by a lawyer of their own choosing. So all of those processes would have gone through. They will be heard. They have right to counsel. They have right to argue their case. When a determination is being made, they are aware of where the chips are falling.
Guys,
but I can understand why we will argue this, but the Constitution doesn't require that they put that in.
Well, the number is 024-366-2001. 024-366-2001. That's Dante's Fashions. They make my shirts for the show, so give them a call and get your shirt. They are not the EC, so you can't call. So 024-366-2001. Get yourself a nice shirt. But I want to say thank you to my 2 brothers in the house, Malik Dabo and Evans Mensah. I told you it has been a phenomenal show, but it's only just news just broke, so I'm sure it's let's watch this space. Interesting times ahead. Thank you very much for watching. We'll be back to do this all over again. Guys, thank you.